Good morning, good afternoon, and good evening. Welcome to Course 9 of the Monique and Roland Vale People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is Indigenous Nations and Peoples Critique the International Law System. Our distinguished faculty includes Hiroshi Fukore, Nick Estes, and Natalie Segovia. Each of them will speak for about 35 to 40 minutes. They will then comment on each other's presentations, followed by Q&A with all of you. We have French, Spanish, and English translation. You can select your language at the bottom of your screen. Please put your questions in the Q&A box for our discussion. In the next few days, we will post on our website, peoplesacademy.net, the faculty presentations in English, French, and Spanish, along with PowerPoints and links to relevant articles. You will receive an email when it is posted on the website. This course will examine and critique from an Indigenous viewpoint the existing system of international human rights and humanitarian law, which has developed since the establishment of the UN Charter in 1945. This state-based system has mostly excluded from and frustrated meaningful participation for the 5,000 plus Indigenous nations who have existed, some for thousands of years before the modern state system. The colonialist legacy of the powerful states affects the ability of Indigenous nations to enjoy their human rights and to influence lawmaking and law enforcement in UN and regional institutions. Any critique must begin with the right to self-determination of peoples, which is enshrined in the United Nations Charter, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights. Indigenous nations, indigenous peoples, are entitled to make a claim of self-determination, of autonomy. However, UN member states, whether to maintain and control land and other property, deny collective rights or prevent reduced sovereignty, deny Indigenous nations their right to self-determination. In the 21st century, there are still UN member states who say that Indigenous peoples are only indigenous populations, ethnic minorities with no right to autonomy. For advocates, the UN human rights system has adopted an internal or minimalist position on self-determination, which limits the ability to obtain effective remedies, such as restitution. Our faculty will discuss practice before human rights bodies as advocates for Indigenous peoples, an alternative institution to the International Criminal Court, that is the Nations International Criminal Tribunal, developed by Indigenous nations in cooperation with some states, and specific proposals for reform in the UN. And now it is my great honor to introduce our faculty. Hiroshi Fukore is professor of sociology and legal studies at the University of California, Santa Cruz, and former president of the Asian Law and Society Association from 2018 to 2019. His research examines lay adjudication, Asian law and politics, original nation approaches to international law, or ONAIL, private international law, and race and law. He co-founded the collaborative research network East Asian Law and Society, and the International Research Collaborative, the state and the corporation as legal fictions within the Law and Society Association, or LSA. He is currently serving a second term on LSA's trustee board, and he sits on the editorial board of Law and Society Review. Hiroshi's recent scholarship addresses indigenous rights, environmental justice, and socio-legal transformations with articles in the Asian Journal of Law and Society and Fourth World Journal. His books include People's Prosecution Review Commission and Japan's Prosecution, that was published in 2022. Original Nation Approaches to International Law, published in 2021. Civil Jury Trials Will Democratize Japan, 2020. And Race and the Jury, published in 1993, which won the Gustavus Myers Human Rights Award. His latest work engages the Nations International Criminal Tribunal, NICT, tracing its roots in indigenous resistance and its expansion of justice to encompass ethnocide, femicide, ecocide, and culturecide. Hiroshi will discuss the original nation approaches to international law. Our next faculty member is Nick Estes. He is an enrolled member of the Lower Brule Sioux Tribe and an associate professor in American Indian Studies at the University of Minnesota. He studies colonialism and global indigenous histories, focusing on decolonization, oral history, U.S. imperialism, environmental justice, anti-capitalism, and the Oceti-Sakowin. Nick is the author of the award-winning book, Our History is the Future, Standing Rock versus the Dakota Access Pipeline and the Long Tradition of Indigenous Resistance, which was published in 2019. That book places the indigenous-led movement to stop the Dakota Access Pipeline into historical context. Nick co-hosts the Red Nation podcast and is the lead editor of Red Media, an indigenous-run nonprofit media organization that publishes books, videos, and podcasts. Nick is also a member of the Oceti-Sakowin Writers Society, formerly Oak Lake Writers Society, a network of Dakota, Nakota, and Lakota writers committed to defending and advancing Oceti-Sakowin sovereignty, cultures, and histories. He is also an award-winning journalist whose writing has been featured in The Guardian, The Intercept, Jacobin, Indian Country Today, The Nation, NBC News, The Funambulist magazine, High Country News, and The New Yorker. Nick will focus on the first decade of the International Indian Treaty Council and global solidarities with Palestine and anti-imperialist movements. Finally, we have Natalie Segovia, who is a Quechua international human rights attorney and the executive director of the Water Protector Legal Collective, an indigenous-led nonprofit law firm and advocacy organization that emerged from the No DAPL movement at Standing Rock and continues to defend indigenous rights, the earth, and climate justice. As a litigator and advocate, Natalie's work centers on the protection of the earth and the rights of indigenous peoples impacted by forced displacement, desecration of sacred lands, and systemic human rights violations tied to extractive industries and mass development projects. For over 15 years, her international work has focused on addressing these harms in rural, often unseen, regions of Colombia, Peru, Bolivia, and Brazil. Nathalie frequently teaches and lectures on Indigenous rights and environmental justice at law schools across the United States. And she was named the Fall Givelber Distinguished Public Interest Lecturer at Northeastern Law School. She holds a JD from Arizona State University and dual BA degrees in political science and Latin American studies from Columbia University. She currently serves on the scientific committee of the Monique and Roland Vale People's Academy of International Law and on the board of directors for Indigenous Peoples' Rights International. Nathalie will discuss Between Recognition and Reclamation, Indigenous Peoples, the International System, and the Future of Solidarity. So we will begin with Hiroshi. Go ahead.
Thank you very much. I want to share my PowerPoint first. Okay. Now, thank you very much for the kind invitation to speak at the People's Academy of International Law. It is truly an honor to be here today. And first and foremost, I wish to express my deep gratitude to Professor Marjorie Cohn, Dean of the People's Academy of International Law. I also wish to extend my sincere appreciation to the dedicated staff, organizing team, and supporting members who have made this event possible. Now, before I begin my presentation, I would like to acknowledge the fact that we gather virtually from many indigenous lands across the globe. So I wish to honor the original caretakers of these lands, their enduring sovereignty, and their continuing contributions to justice and peace. We carry this awareness into our discussion, remembering that the principles of law and justice that we discussed today must include respect for the sovereignty and the resilience of indigenous nations everywhere. Now, today's discussion entitled as Indigenous Nations Peoples Critique the International Law and System invites us to re-examine international law through the lived realities and wisdom and aspiration of indigenous nations and communities across the world. It calls us to imagine a more just and diverse international legal order, the kind that truly acknowledges and respects the sovereignty and voice of original nations. As the first speaker in today's discussion, I would like to introduce an approach that seeks to examine international law through indigenous frameworks and perspectives. This framework is called Original Nation Approaches to International Law, or ONEO, as you see on the screen. Now, you may notice that the international is written with a hyphen. This hyphen is deliberate and actually doing a lot of work. It serves to distinguish the concept of nation from that of the state. ONEO reclaims nation in its original sense, that is, a living community rooted in ancestral land, communal language, and deeply shared tradition, rather than the apex of political power or the dominion of authoritarian institutions. So my today's talk draws from my 2021 book of the same title. And having taught international law from socio-legal, comparative, and cross-national perspectives, as well as myself coming from Japan, where my own heritage connects with Ainu people who have lived in northern Japan for many centuries, I came to feel that our current international legal paradigms could benefit greatly from the perspectives of indigenous and original nations. And these nations existed long before the modern state system emerged. And the original nation perspectives and knowledge systems offer vital insights into the critical examination of international law today. So I will first outline 4 key areas where contemporary international law can evolve by incorporating the paradigms of original nations. So let me outline those 4 key reasons, as you see on the screen, and why we must move beyond the limits of conventional international law and embrace what I call the original nation paradigm. First, conventional international law remains deeply rooted in state-centric system that has been historically sanctioned and maintained largely by North Atlantic powers. And today's United Nations, with its 193 member states, reflects this system. And you must be a state to become a member of this global management system. This effectively excludes indigenous and original nations, as well as stateless people. Indigenous sovereignties, which predate the modern state system, are left unrecognized within the legal architecture of the United Nations. Second, existing legal order sustains the Western-dominated global hierarchy. This statist taxonomy of the world, dividing the world into first, second, and third worlds, reproduces a core periphery structure that privileges the global north while relegating much of the global south to the margins of governance and lawmaking. This very language and logic of this unequal hierarchy carries the imprints of colonialism and its legacies. Third, these hierarchies and the system of domination are perpetuated through what we call the Westphalian legacy. Originating in the 1648 Treaty of Westphalia, this model enshrines the principles of state sovereignty and non-interference. It stabilizes the relationship among European states, but it simultaneously excludes and delegitimizes non-European legal systems, their cosmologies, and governance traditions. Today, this Euro-American conception of sovereignty became the global standard, marginalizing indigenous nations on original polities that governed themselves long before the birth and imposition of the modern state. Finally, the original nation approaches the international law, or ONEO, seeks to re-examine this paradigm. The ONEO recognizes indigenous and original people as sovereign nations in their own right. It demands accountability for crimes such as ecocide, culturicide, and femicide, which remain largely outside the jurisdiction of the existing international tribunals. By centering the perspective of the original nation, ONEO invites us to reimagine international law as international law with a deliberate hyphen, a law relation between nations and peoples, not merely among states. It opens the possibility of an international legal system grounded in reciprocity, ecological respect, and intercommunal coexistence. Now, I would like to turn to the relationship between state and the nation, to concepts of two geopolitical entities, often conflated, but fundamentally remain distinct. The state, its collective legal entity we now take for granted, is not a natural phenomenon. It's a legal and political invention, a cognitive construct born, altered, and often dissolved over time. History reminds us that states are ephemeral. And consider the Republic of Texas, which existed from 1836 to 1845, later absorbed into the United States. The Soviet Union existed from 1917 to 1991, or the dissolution of Czechoslovakia, and even Yugoslavia into smaller entities, including Kosovo's continuing struggle for recognition. Even South Sudan, established in 2011 after separating from Sudan along oil-rich borders, illustrates how new states often emerge through corporate and geopolitical interests rather than genuine self-determination. Even every state is built on manufactured narratives, songs, flags, symbols designed to legitimize its existence. These state myths often rely on erasing or assimilating pre-existing indigenous nations, which were labeled as non-existent or rendered invisible in state narratives and its own histories. The invention of statehood came at the cost of silencing traditional and deeper form of sovereignty. As Vladimir Lenin and other prominent scholars had argued, modern state has often functioned as a prison house of indigenous and original nations. Its borders confine and divide people who lived across those territories for centuries. Efforts for indigenous nations to assert their sovereignty or resist extractive projects are frequently criminalized, their leaders labeled as separatists, insurgents, even socialists, or even communists. Yet these struggles are not acts of rebellion against the order, but expression of indigenous sovereignty and the defense of land, life, and community against the encroachment of the state and corporate power. Now, in contrast to the artificial construct of the state, nations are organic and living communities, rooted in shared memory, common history, and enduring relationships to land, long before the state system imposed itself through European expansion. These original and indigenous nations flourished as self-governing societies, maintaining distinct languages, culture, and history. Unlike the state, nation is not invention. It is living continuity, as the indigenous scholar Winona Leduc reminded us that the indigenous nations constitute the host world upon which state structures were later built and imposed. Indigenous sovereignty does not derive from constitutions or charters, but from the land itself and from the collective life of the people. And according to the United Nations estimate in 2011, there are about 370 million indigenous peoples worldwide, representing more than 5,000 original nations. A later World Bank estimate came out 5 years ago, raised this figure to 460 million people, still designating roughly about 6% of the global population. Meanwhile, the Center for the World Indigenous Studies, based in Washington, suggests that the true number could be far higher, even up to 1.9 billion people, or about 1/4 of humanity, where they included all self-defined, land-connected, and culturally continuous people who recognize their own sovereignty and contribute to the ongoing process of world making. Even within Europe, more than 100 indigenous nations persist today, as you see on the right side of the screen. Many continue to maintain their languages and governance systems, and some have sought independence and formal recognition in recent decades. And taken together, these examples remind us that the nations endure where states rise and fall. They embody living sovereignties, rooted not in power or borders, but in memory, kinship, and sacred continuity between people and the earth. Now, coming from Japan, having spent some time researching in the southmost island of Ryukyus, today it is called Okinawa, I wish to highlight the continuing struggles of the Ryukyuan people for independence and self-determination. In 1981, Ryukyuan representatives expressed their strong desire for independence and drafted the Constitution of the Republic of Ryukyus, which I will share shortly. For centuries, Ryukyu Kingdom thrived as prosperous maritime nation in the East China Sea, maintaining tributary relations with Chinese dynasties, including Qin Dynasty, while preserving its autonomy and distinct identity. In 1879, this newly formed the Meiji state of Japan annexed Ryukyu Kingdom and absorbed it into its expanding imperial empire. The Battle of Okinawa in 1945 brought devastating loss, about 150,000 lives, nearly 1/4 of the island's population. After the war, the islands became a U.S. military colony and a key outpost of the U.S. power in the Asian Pacific, marked by pervasive military sexual complex under U.S. supervision. Even after Okinawa's reversion to Japan, 1972, U.S. retained extensive control. Today, over 70% of all U.S. military bases in Japan are concentrated in Okinawa. Despite widespread opposition and daily protests against ongoing base construction in Henoko, which you can see on the right-hand side of the screen, the Ryukyuan people continue to face militarization and land appropriation. Yet no domestic or international legal framework currently exists to restore Ryukyuan sovereignty or fulfill their call for demilitarization. Now, this is the Constitution of Republic of Ryukyu. Let me now read some of its contents. The preamble begins with the powerful declaration, "We, having suffered centuries of exploitation and oppression under the feudalistic, imperialistic rule of China, Japan, and the United States, have finally achieved our long-held goals of freedom, independence through a process of democratic revolution." This statement captures the historical suffering and enduring aspiration for freedom among the Ryukyuan people. It situates their independence not as a symbolic act, but as the culmination of long struggle against the overlapping system of domination. The aim and principle outlined in the Constitution emphasize the three core commitments: to prevent the tragedy of war, to endure peace throughout the land, and promote harmony with other domestic nations. These principles echo both universal longing for peace and a specific local memory of devastation experienced during the Battle of Okinawa. Now, transitional clause of the Constitution is also striking. It declares that the Constitution shall become null and void the day prior to the Republic of Ryukyu's full incorporation in the Global League of Governments, should such a body be successfully established. In other words, the Ryukyu Constitution envisions sovereignty not as isolation, but as a participation in more just and inclusive global order, where all nations, including original indigenous ones, stand as equals. This document articulates the vision of post-colonial sovereignty and global solidarity. It aligns closely with the principles of original nation approaches to international law, or NAO, by affirming the inherent rights of original nations to self-determination and to recognition as co-equal members of the global community. Now, despite the desire of the Okinawan peoples and communities, there are other limits of international law in the Ryukyu, particularly in Okinawan context. Despite the clear desires of Okinawan communities for self-determination and independence, international legal mechanisms today do not fully recognize or support these aspirations. Locally, Okinawans have taken action. They've filed domestic lawsuits and administrative complaints to address their grievances, but these efforts face significant barriers. First, US-Japan Status of Forces Agreement, or we call it SOFA, grants broad immunity to US military personnel. Likely, the Articles 4 and 7 of SOFA limit Japan's jurisdiction over US military activities and even environmental harm caused by these activities. Okinawan communities have also raised complaints with the UN human rights bodies, addressing issues like serious pollution, contamination of land and water, sexual assaults by US military personnel, and the loss of cultural autonomy and self-determination. Yet, when it comes to international courts like ICC or ICJ, Okinawa has no effective legal path. International law is largely state-centric. Only recognized states have standing before ICJ. Okinawa, as an original nation, lacks international legal personality. On top of that, structural immunity under SOFA shields US forces from both domestic and international accountability. The result is disappointing. Despite local efforts and international advocacy, Okinawans have no legal avenue to pursue justice, protect their environment, or fully exercise self-determination. Okinawa's case really highlights a broader limitation of international law. That is, it leaves non-state communities without effective protection, especially when powerful states are being involved. Now, before we move on to the Nations International Criminal Tribunal, or NICT, which through its 110 articles attempts to grant legal personality to indigenous nations and create a platform within the international legal system, it is important to acknowledge the fundamental failures of the state-centric judicial mechanisms under the current framework of ICC and ICJ. The first, international justice overwhelmingly state-centered. These courts also focus on individual criminal responsibility rather than addressing state, corporate, or other collectivist accountability. There is no effective mechanisms to hold systems or institutions accountable, and enforcement is often selective and politically influenced, leaving structural harms largely unaddressed. Second, there are significant blind spots in international law. For instance, ecocide, which is widespread environmental destruction outside wartime, is not yet recognized as international crime. Similarly, ethnocide or culturicide, involving systemic erasure of culture, linguistic, and identity markers, falls outside the current scope of genocide law. Gendered violence also faces limitations. While acts such as rape or sexual slavery are partially covered, structural and systemic forms of femicide or gendercide, especially involving indigenous women and activists, remain largely unpunished. The core problem here is that international law tends to target extreme, visible acts of violence, but leaves structural harms like environmental devastation, cultural annihilation, and systematic gendered oppression beyond the reach of justice. Recognizing these limitations help us understand why new legal innovations such as NICT are necessary to fill the gaps left by traditional state-centered international legal institutions. Now, this slide introduces the Nations International Criminal Tribunal, or NICT, an innovative international legal platform designed to address the gaps left by state-centric judicial systems. The NICT was established through the collaborative efforts of lawyers, scholars, investigative journalists, indigenous activists, and allied indigenous nations. Its development was spearheaded by the Center for the World Indigenous Studies under the leadership of the late Dr. Rudolf Risser, who served as executive director for many decades. The charter of NICT, along with a special issue dedicated to it, was published last June in the Fourth World Journal, its flagship journal, and document is openly accessible by the link provided on this slide. The NICT represent a significant advancement in international law because it formally recognizes international nations as legal entities with standing to bring cases. It addresses structural harms often ignored by traditional international courts, including culturicide, land disposition, and historical injustices, and adjudicates crimes committed against original nations. Importantly, NICT emphasizes restorative and community-based justice, prioritizing healing and local empowerment over purely punitive measures. It also integrates indigenous customary laws, values, and local principles into its procedure, making it culturally grounded alternative to the state-centered models of justice that dominates ICC and ICJ. Now, this slide highlights four major significance of NICT. The first is inclusive justice. NICT actively involves indigenous judges, elders, and knowledge keepers in decision-making, ensuring that the proceedings reflect community wisdom and traditional protocols. It also conducts multilingual and intercultural proceedings, respecting the diverse cultural contexts of the parties involved. Second is the holistic remedies. Unlike conventional courts that prioritize punishment, NICT emphasizes healing, restitution, and reconciliation. Its approach moves beyond the punitive frameworks to address the restoration of communities and cultural life, ensuring that the justice is not only legal, but must be social and cultural. Third is the decolonized paradigm. NICT expands the understanding of sovereignty and accountability by addressing moral and historical gaps left by colonial legal frameworks. It also encourages cooperation among indigenous nations worldwide, fostering solidarity and shared strategic plans for justice. Finally, it is a complementary role. NICT works alongside institutions like ICC and ICJ, filling the gaps where conventional international law falls short. It provides a platform for justice, specifically for indigenous nations, ensuring that the systemic harms, cultural erasure, and the historic injustices, which are often overlooked by traditional courts, can be addressed. Now, we last focus on the innovative methods of indigenous participation and NICT. First, NICT incorporates jurado indígena in Spanish, or indigenous juries in English, which was adopted in Argentina since 2011. Those juries are composed of diverse members, including half of the jury members coming from equally from indigenous and non-indigenous communities. That would ensure that indigenous perspectives and values are directly incorporated into verdicts. Second, there is the Prosecution Review Commission, or PRC, as seen in Japan. The PRC reviews decisions of non-indictment rendered by the state prosecutors, providing an additional layer of community oversight and accountability, especially over activities that state prosecutors are more reluctant to indict and prosecute, including corporate entities, powerful political elites, and government officials and institutions. This is to make sure that the justice reflects the concerns of all affected communities, rather than the only formal legal procedures. The third, as stated earlier, the NICT emphasizes restorative justice. The focus is on reparation, compensation, and the broader processes of healing and reconciliation, rather than solely on the imposition of punishment. Overall, indigenous participation integrates traditional knowledge, cultural values, and community perspectives into the formal justice processes. This approach creates a more inclusive and culturally sensitive legal framework, bridging the gap between international law and lived realities of indigenous nations and peoples. Now, this concludes my presentation on AIL and recentering of international law through the perspectives of indigenous peoples and original nations. And I very much welcome your questions and look forward to deeper discussions on these very important issues. Thank you very much.
Thank you so much, Hiroshi, for your provocative presentation about the contradiction between states and nations and the limitations of the ICC and the ICJ to provide real remedies for violations of the rights of nations and the structural harms they suffer. And thanks for explaining how the NICT is preferable to the traditional international law system, but how it complements it in a holistic way. Thank you so much. And next we have Nick. Go ahead, Nick.
Hamatakiapi, thank you so much for inviting me to this talk, and thank you, Marjorie, for your work putting this together, and also to Aaron for running tech and making sure that we are gathered in this virtual space. I really appreciated Hiroshi's presentation. Mine is a little bit more historical in the context of looking at a specific moment in history. So I am maybe sort of elaborating on some of the things that Hiroshi had brought up, but I'll start screen sharing right now. So you'll see that. Okay. In mid-January 1980, John Thomas, a Lenape and Shawnee member of the American Indian Movement, or AIM, and John Adams, a Methodist minister, waited outside the Tehran office of Abul Qasim Sadegh, Director General of the Foreign Press for the newly established Islamic Republic of Iran. The pairing of an indigenous activist and a white American minister seemed unusual, but the mission was serious. Both men had hoped to ease growing tensions of a geopolitical crisis. After the US-backed Shah of Iran was ousted in 1979 and fled the country, trust in Americans quickly dissolved in Iran. On November 4th, 1979, Iranian students stormed the US Embassy, took 52 hostages, and demanded the Shah be extradited to stand trial in Iran in exchange for the captives. Earlier that month, Thomas had arrived in Tehran representing the International Indian Treaty Council, the international arm of AIM, at the World Conference of Liberation Movements, which united various national liberation struggles. Because of the Treaty Council's ties to the Palestine Liberation Organization, or the PLO, a trusted ally of the Iranian Revolution, after the takeover of the embassy, the students approached Thomas with a request: deliver letters from the US hostages to their families as a humanitarian effort. Though at first reluctant, Thomas agreed to the mission. For his part, John Adams had served as a negotiator during the siege of Wounded Knee in 1973 and was a trusted AIM confidant. By the time Thomas and Adams arrived in Tehran, Sadiq had expelled US journalists because of their often exaggerated reporting on the country, its revolution, and Islamic movements more broadly. They implemented what became known as the hostage mail exchange service, and its role, it had a wide-reaching role in not just Iran, but also legitimizing the International Indian Treaty Council as a international player. But the connection between Turtle Island and Iran, or we could call it East Asia or West Asia, I'm sorry, bridged two distinct cultures and peoples, creating what many have called an unexpected alliance. This work and this particular event should be put in the context of the formation of the International Indian Treaty Council, which happened in 1974, particularly after it gained non-governmental organization status at the United Nations in 1977. But it also should be put into the context of a longer tradition of American Indian diplomacy, one that sought to go beyond the sort of frameworks of the nation state, as Hiroshi has been talking about. So activists like Thomas saw themselves as part of a global struggle, seeking solidarity with and recognition from peoples of the so-called global periphery. The rise of the International Indian Treaty Council, which from now on I'll just call the Treaty Council, just for the sake of brevity, demonstrated a growing consciousness among American Indian activists that they occupied a space within the imperialist core of the United States while not being entirely of it. By the time of the 71-day siege at Wounded Knee in 1973, and especially through its subsequent international work, AIM began to frame itself as a national liberation movement. This identification wasn't initially clear upon the group's founding in 1968, but it was a key aspect of the Treaty Council's international relations. Existing scholarship argues that the Treaty Council attempted to channel AIM's aspirations for national independence into international indigenous human rights, the International Indigenous Human Rights Movement at the United Nations. But the United Nations was less a destination than a process. While the Treaty Council pursued NGO status within UN human rights frameworks, however, AIM activists still fashioned themselves and the goals of American Indian nations more broadly as a national liberation movement, even if they had been excluded from formal decolonization processes under the UN system. In the eyes of the world, AIM had taken up arms against the United States to defend the Oglala people and their treaty lands from both the corrupt tribal government and the overreach of federal authorities. In the process, they declared the independent Oglala Nation separate from the United States. The standoff, which resulted in the deaths of two activists, was followed by a brutal federal crackdown known as the Reign of Terror, which claimed the lives of dozens more. Despite the violence, the siege at Wounded Knee earned AIM international recognition and respect, earning it a place in the broader global struggle for self-determination and against imperialism. AIM's and the Treaty Council's role in this pivotal moment is largely missing from existing scholarship on power movements and anti-imperialist internationalism, which periodizes the rise and fall their rise and fall with the growth of the ebbing and the growth and ebbing of U.S. anti-war and student movements. AIM's activities through the work of the Treaty Council, however, persisted beyond the end of the Vietnam War, charting a different timeline for the Red Power movement. And according to oral history, interviews with Treaty Council and AIM activists, the international work was partly a prophecy and partly the work of generations of Indigenous peoples. Go to the next slide. This exchange, or this hostage mail exchange service, was actually recognized by the United Nations Executive Office of the Secretary General. This is a thank you letter that they'd issued, and then on the right-hand side, there was a letter written by one of the parents of the hostages thanking AIM for opening up sort of a channel of communication with their family members. This mail exchange service only lasted for about 4 months before it was ended for a variety of reasons. But nonetheless, it sort of legitimized the American Indian movement in the eyes of, not just the United Nations, but these other struggles as a sort of trusted ally, not just in the region, but throughout the so-called global periphery. This is John Thomas. I just wanted to put a picture up with him. He's an elder from the Delaware tribe of Indians. He's Lenape and Shawnee. But I sat down with him for multiple interviews to discuss this history, among other things. And as you can see, still has that olive drab duffel bag with the hostage mail exchange service on there. And I highlight this history because I think when we talk about international Indigenous human rights, we typically see it at a kind of this larger framework of the United Nations and the complex sort of processes that exist. But today, in this sort of talk and the research that I'm doing, I'm looking more at the sort of horizontal relations of everyday people sort of participating in these particular movements. And this is part of a book project that I'm currently working on called We Are Power, People's History of the American Indian Movement, which looks and examines the American Indian movement and the Red Power movement within a longer time frame. Typically, histories about Red Power frame it within the 1960s and the and sort of declining in the mid 1970s. But what I found, talking with various people such as John Thomas, is that that's simply not the case. That one of the lasting legacies is the Indigenous International Movement, and in some ways, some of the bigger actions that don't get recognized happened in the 80s or after the movement was sort of declared defunct. So that's sort of the take of this larger book, but I want to focus a little bit more on the foundations of the International Indian Treaty Council. And in this particular meeting that I had with John Thomas, he asked me several times if I'd ever heard of this prophecy of the Red Giant. And that's subsequently the title of an article that was just published. I'll share it with you. It was published like literally several days ago. That I'll share with you in the chat that you can all check out. And I draw a lot from that article and other article and the book project for the remainder of this particular talk. So June 1974 marked a pivotal moment in the Indigenous movement in the United States, one that resonated deeply with the attendees of the First International Indian Treaty Council, but went almost unnoticed by the American public. In the past, a desire for spectacle sometimes overtook substance. The press that swarmed Wounded Knee during the intense 71-day siege, when federal troops fired thousands of rounds into the hamlet, was nowhere to be found when thousands of delegates from 97 Indigenous nations from the Western Hemisphere gathered in Mobridge, South Dakota, to discuss the serious business of Indigenous treaties. In addition, the federal government's attention to the Trail of Broken Treaties occupation of the Bureau of Indian Affairs headquarters in 1972, when the protesters set up what they called the Native American Embassy and demanded an audience with President Nixon, was far more enthusiastic than its reception of the outdoor conference in the Northern Plains 2 years later. Whereas the Trail of Broken Treaties sought to generate domestic support for Native rights, the Treaty Council in 1974 recognized the limitations of that approach and instead appealed to what they called world opinion and called for the solidarity from, quote, other nations, especially small oppressed nations, end quote. It was a significant shift in the evolution of Indigenous activism, no longer solely focusing on winning public sympathy in the United States. AIM and the Treaty Council aligned themselves with global decolonization movements, embracing a broader anti-imperialist stance that directly challenged US hegemony. And this resulted in the drafting of the Declaration of Continuing Independence. It's a really foundational document. I recommend you all go and read it. If you just Google it, it will should come. The text should come up. It charged the United States with genocide and reaffirmed the 1868 Fort Laramie Treaty signed between the Ochete-Shawkoni and the United States, which ended nearly a decade of war and promised a permanent home, quote, for the Indians, as a foundational instrument for advocating for broader treaty rights for all Indigenous peoples of the Western Hemisphere. The Declaration positioned the treaty not just as a historical agreement, but as a living framework for asserting Indigenous sovereignty. Its continued violation was not only evidence of the US failure to honor its original agreements, but also a reflection of the imperialist nature of the United States itself. In response, the Treaty Council pledged unwavering support for all Indigenous nations and peoples in, quote, their respective and collective struggles concerning international treaties and agreements violated by the United States and other governments, end quote. So implicit within this sort of framing, I think what I'm trying to draw out in this particular piece and talk is that American Indian activists at this particular moment in time had developed an anti-imperialist framing that often gets overlooked. And it's deep, I think it's deep within the tradition of American Indian intellectuals, you know, going back at least a century. So for example, in 1969, in his pivotal book or seminal book, Custer Died for Your Sins, Vine Deloria Jr. Implored the rest of the world to look at the treaty history of the United States with Indigenous nations to understand the imperialist nature of the United States and to understand the taking of Indigenous lands as akin to how European nations went through and carved up places like Africa and Asia and the Middle East. So at this particular meeting, there were a lot of figures that you might know today, but I want to just highlight some of the people who were considered the traditional leadership and elders. Traditional leaders and elders were the bedrock of unity at the gathering. Among them was Hunkpapa Elder Evelyn Gabe, a direct descendant of John Grass, a Hunkpapa chief and treaty council leader who resisted allotment in 1887, and that's a federal policy to divide up native land, reservation lands. For Gabe and for many American Indians, the term traditional carried a meaning far removed from the notions of conservatism, often associated with the word in Western politics. Quote, our tribal governments are based on bands and clans, he explained to the attendees. That is what makes us traditional, end quote. For Gabe and many other Indigenous leaders, traditional referred to a system of governance grounded in kinship laws and tribalism, not the rigid competitive frameworks of Western political systems. Unlike the winner-takes-all elections and party-driven politics of modern liberal states, Indigenous governance was based on striving to maintain harmonious relations and to uphold the collective well-being of the community. Power and authority were tied to the ability to uphold these relationships, not to individual control or dominance. Indigenous leadership was rooted in consensus building and decision making that reflected the bonds of family and kinship, rather than partisan divisions. Major decisions such as treaties and diplomacy were not the result of a single individual's victory or authority, but rather the product of collective consensus among people tied by a shared responsibility and familial ties. This approach to governance stood in stark contrast to the US government's view of treaties, which is often reduced to mere transactional land cessions, one-sided agreements that reinforce colonial power. To Indigenous peoples, however, treaties were expressions of collective authority, mutual respect, and long-standing relations with other peoples in the natural world. But this sense of collective responsibility was not reciprocated by the US government, which often viewed treaties as concessions to the superiority of a colonizing power. After this particular treaty conference, there was the move to go to the United Nations to hold. It was to take essentially the treaties to the United Nations and to take the U.S. government to the World Court to get the genocide against Indigenous peoples in the Western Hemisphere recognized. Of course, they faced particular problems in doing so. But before I get into that, I think it's worth talking about this kind of period of repression, because frequently we understand, if you know anything about the American Indian movement and the repression by federal authorities, it's often framed in the term of COINTELPRO, or the counterintelligence program that was used against American Indian activists. Even though the counterintelligence program was officially retired by the FBI in 1971, the program that did target American Indian activists had been ongoing at least from the 1950s, and this is evident in the FBI documents. These weren't actually COINTELPRO operations. They were actually dedicated operations to target specifically Native activists. And one such activist who was named early on in these files was a leader by the name of Wallace Madbear Anderson, who was a Tuscarora activist and trade unionist. Madbear's international efforts, like those of Thomas and the American Indian movement in the 1970s, caught the eye of the Federal Bureau of Investigation, or FBI, which labeled him, quote, highly knowledgeable on matters concerning Indians, their history, and the law, end quote. In 1958, he led actions against the theft of Tuscarora land by the state of New York Power Authority, employing, quote, physical and passive resistance, according to an FBI report. A year later, Madbear had embarked on even more daring mission. He traveled to Cuba with a delegation of Miccosukes from the Florida Everglades, who were at the time seeking federal recognition as a distinct tribe separate from the Seminoles. While in Havana, they met with Fidel Castro, who recognized the Miccosukes as a sovereign nation and offered them land, telling their leader, Buffalo Tiger, quote, remember, when you have no place to live, come live here, end quote. Upon the delegation's return, the FBI swiftly investigated the trip, questioning the group about their interactions with Castro. In exchange for their promise to sever ties with Cuba, the federal government agreed to reconsider the Miccosukes' application for federal recognition, which was ultimately granted in 1962, also the same year as the Cuban Missile Crisis. The interaction between Miccosukes and the Cuban government illustrates the power of tribal sovereignty as a tool of international diplomacy, not merely within the confines of US law, but also as an act of defiance against the colonial state. And by leveraging Cold War tensions, Native leaders like Madbear and Buffalo Tiger were able to extract concessions from the US government, showing that Indigenous sovereignty could transcend national borders and be defined not only by relations with the colonizing state, but by international alliances. This episode underscored the early seeds of Indigenous internationalism, and Mad Bear's activism demonstrated how Indigenous nations could assert their sovereignty on the global stage and how international recognition could become a vital component of Indigenous resistance. It's also worth noting that the FBI was first and foremost interested in Native activists' relationships with foreign governments, or in particular, they were looking for, communist governments. So it's interesting. We think of domestic surveillance at this particular time period as suppressing domestic dissent, but the evidence from the FBI itself, it was actually looking specifically at indigenous international or indigenous activists' attempts to create international and diplomatic relations with other movements throughout the world. And this is actually evident in the first sort of FBI reports on the American Indian movement, and some of the Red Power activists really interested in their connections to any government labeled communist or an enemy of the United States. And this continued, well into the 1980s with the formation of the International Indian Treaty Council, but it also was looking specifically at the internal relations of Indigenous activists with other organizations such as the Chicano movement and the Black Power movement, which I detail in this particular piece. But nonetheless, I think what's also important to think about, especially as we enter into the 250th anniversary of the signing of the Declaration in 1776, is that it was very clear from the founding of the United States, declaring Indigenous nations as the merciless Indian savages on the Western frontier, that the sort of Red Scare, as we know it, in the anti-communist Red Scare in the United States, actually began with looking at and targeting specifically Indigenous sovereignty and Indigenous internationalism. And I think that's an argument that I hear a lot of Treaty Council activists have made, but not so much in the scholarship. And this sort of attempt to create international alliances, had its effect on more liberal sort of alliances with and sympathies towards the American Indian movement. After one of its FBI informants, who was actually somebody who claimed to be Indigenous, but was actually just a white cop from Iowa named Doug Durham, had given testimony to the Senate about the threat that the American Indian movement had posed in 1976. Many of the sort of sympathies that the AIM and Red Power had in the sort of white liberal press began to dissipate. And this is a quote from on September 7th or 17th, 1976. Jack Anderson, the Pulitzer Prize winning journalist and self-described, quote, friend of the American Indian movement, spoke to ABC's Good Morning America to denounce the movement. It was, quote, his unpleasant duty to report, he told viewers, repeating the accusations made by Douglas Durham at the Senate, this 1976 Senate hearing, that members of AIM, quote, have been in touch with world terrorists, having dealings with the Palestine Liberation Organization, the Irish Republican Army, the Cuban Communists, and various other Trotskyites, militants, and crazies, end quote. So his denunciation of the movement based on Durham's testimony damaged AIM's popularity with the mainstream press, and perhaps sort of sabotaged any sort of histories or scholarly studies of this particular time period, because by 1976, the movement, many historians have kind of declared the movement as sort of over and ending. But to sort of wrap up this portion of my talk, I want to turn to the question of Palestine, because this, as I began this talk, I talked a little bit about how the American Indian movement had legitimacy in places like Iran because of its ties to the Palestine Liberation Organization. And this is something that came up frequently in my conversations and interviews with the elders of the International Treaty Council, not just the elders from the Treaty Council, but also elders back home from the reservation who talked about first meeting Palestinians at these Treaty Council events and having them very present in the movement at the time. And this is a photograph, actually, you can't see it. It's a photograph of the Wounded Knee massacre site. This was taken 2 years ago on Liberation Day, and it commemorates, it's February 27th, commemorates the liberation of Wounded Knee when dissident Oglalas and the American Indian movement took over the Wounded Knee site and began this sort of siege, against the U.S. government, but also a corrupt tribal government. And you can see next to the AIM flag and the staffs, there's a Palestine flag. And I just thought this was kind of really symbolic of, even 50 years later, this sort of recognition exists. And it's still, if you went to the Black Hills Powwow, which is one of our largest social gatherings for the Ochete Shakoi, there is a massive banner that said from Chesapa to Gaza, meaning from the Black Hills to, to Gaza, we recognize that our struggles are one. So the American Indian movement, never fully embraced, Marxism, even though it kind of gets cast as a communist, sympathetic communist organization by these sort of liberal critics. But it did take up the Palestinian cause as its own, pointing to the parallels of Palestinians and American Indians as unrecognized nations under the boot of European imperialism and settler colonialism. These similarities highlighted shared histories of oppression and common modes of resistance. Increasingly, AIM looked to the Palestinian struggle for guidance and inspiration in waging their fight on the international stage, understanding that both groups had to rely on novel and unconventional methods to gain recognition. In late 1973, Yasser Arafat, the leader of the PLO, which was created in 1964, declared that the global struggle had shifted from the jungles of Southeast Asia to the plains, mountains, and cities of the Middle East, with the liberation of Palestine at its core. The character and geography of that struggle had evolved from the Vietnamese communist guerrilla fighters to the Palestinian Fedayeen. A new wave of transnational Palestinian guerrilla action marked an increase in the power of non-state actors in the international system. This shift provoked a strong response from the United States against what it called international terrorism to safeguard its strategic interests in the region, particularly in support of for Israel. At the United Nations, the PLO waged an unconventional struggle, one rooted in the rising tide of the Third World Movement. This political bloc, composed of developing and decolonizing nations, sought solidarity among the peoples of the global South. The Treaty Council, representing emerging indigenous nations, found resonance in the global wave of revolutionary nationalism. Bill Means, a co-founder of the Treaty Council, recalled a pivotal moment in 1978 when he met PLO leaders in Beirut, Lebanon. Reflecting on the encounter, he described he described a meeting with Yasser Arafat. It was a pretty happy and proud time to see people struggling, especially in refugee camps in Palestine, which is almost exactly how reservation life used to be during my parents' time. Forced removals to boarding schools, not allowed to speak your language, this type of stuff, end quote. What Palestinian refugee camps shared similarities with Indian reservations, Means observed a key difference in how the Palestinian movement had overcome internal factionalism. He noted that Palestinians had unified under a single national organization, while Indian country was politically fractured. They decided to come together under one flag, one nation, instead of Palestinian resistance forming the PLO. In contrast, his own nation, the Ochete Shakoi, had tribal councils on each reservation and various treaty councils representing different grassroots groups, which were not united. Sometimes they conflicted with each other, as they had during the Siege of Wounded Knee in 1973, when a traditionalist faction fought to overthrow the tribal government. Means saw AIM pushing for a national government or national organization that represents all of our people, our whole nation at the United Nations. The Treaty Council demonstrated that, like the Palestinians, American Indians were colonized peoples, and that reservations were, in effect, colonies of the United States, colonies that deserved decolonization. Since the Treaty Council rejected violence except for in self-defense, and AIM's period of armed struggle had mostly ended, Means argued that American Indian treaties represented the best case for international recognition and decolonization. These treaties recognized by the U.S. Constitution as international agreements between sovereign nations formed the legal basis for their argument. Drawing on the example of Zimbabwe, formerly Rhodesia, where an armed movement and political struggle had ultimately overturned white supremacist rule, Means emphasized that decolonization was possible through political and revolutionary means. I'll kind of summarize some of these other ones, but there was survival schools that were created by the American Indian movement, which brought youth, or which created sort of a youth wing to Red Power. And many of these children and students from the survival schools actually attended these international delegations in places like Beirut. I interviewed Marcella Gilbert, who's the daughter of Madonna Thunderhawk, who was a leader in the American Indian movement and on the Treaty Council. And she describes the sort of interaction she had in Beirut with a young Palestinian sniper, who was this woman who was actually missing part of her arm. But it really set in her mind, it really stood out in her mind, the stakes, or the extent to which, Zionism had destroyed a people, but the extent to which the United States was willing to support this imperialist project in the Middle East. So it was also inclusive of not just sort of these male leaders, but also women and children who were part of these cultural and political exchanges with Palestine. There were also, I found a really beautiful archive of newspapers and newsletters that the American Indian Movement and the Treaty Council had published. There's Treaty Council News, as you can see there. This is in the Jackie Warlito Center at the International and Treaty Council offices in Tucson, Arizona. And these other newspapers are the Oyate Wichaho was a sort of locally or regionally distributed newsletter that had a run about, I think it was like a circulation of about 15,000, but it ran from like 1979 to 1985. And in the pages of these papers, they had all these report backs from various indigenous struggles throughout the world, including the anti-apartheid struggle in South Africa, the Namibian People's Movement, SWAPO, the South. I think I forgot the name, what SWAPO means, or the acronym. But also, it included a lot of report backs from Palestine. And as you can see in the corner, the bottom right-hand corner, there is on one frame, there's Yasser Arafat holding up a rifle, and in the second frame, there's a quote that says, "The results of U.S. aid to Israel," and it has a Palestinian man holding the mutilated body of a Palestinian child. But in the bottom left-hand corner, there's a letter from a political prisoner, Leonard Peltier. And this was a letter that he had published in solidarity with the PLO during Israel's invasion of Lebanon. And I'll just sort of read this section and wrap up my talk. The criminalization of resistance fighters, whether they're Palestinian or American Indian, highlights a connection between American Indians and Palestinians. On July 13th, 1982, from Marion Federal Prison in Illinois, imprisoned AIM member Leonard Peltier wrote a letter to the PLO expressing his, quote, uncompromising solidarity with the Palestinian and Lebanese people's struggle against the Zionist forces of Israel, end quote. Peltier was serving 2 consecutive life sentences for the murders of 2 FBI agents at Pine Ridge in 1975, while his co-defendants were acquitted on the grounds of self-defense. He has consistently maintained his innocence, gaining international support as a U.S. indigenous political prisoner. In his letter, Peltier referenced the Zionist army's invasion of Lebanon and the siege of its capital, Beirut, as, quote, a genocidal campaign, likening its actions to the 7th Cavalry, a regiment led by George Armstrong Custer, who is notorious for his role in the Indian Wars. Custer's regiment faced defeat at the hands of a Lakota Cheyenne Arapaho alliance during the Battle of Greasy Grass in 1876. In an act of revenge, the 7th Cavalry later carried out the Wounded Knee Massacre in 1890, killing hundreds of surrendering Lakota ghost dancers. Peltier not only drew parallels between the colonial massacres of Palestinians and Lebanese and those of American Indians, but also called for a united front of the 4 colors of the peoples of the world, quote, quote, red, black, yellow, and white freedom fighters. If I were free today, Peltier wrote, I would take our red warriors to fight side by side with the freedom fighters of the yellow to smash the imperialist forces of the United States and Israel, end quote. He signed the letter, quote, as a prisoner of war within the belly of the beast, referring to his incarceration at Marion Federal Prison. Peltier's letter indicates that AIM viewed its struggle as a fight against U.S. imperialism. Imprisoned American Indian activists such as Peltier thus became prisoners of war or political prisoners criminalized for their actions in defense of indigenous homelands, much like the Palestinian and Lebanese resistance fighters who defended their territories against Zionist invasion were variously labeled as terrorists. That fight required more than taking up arms, but forming political alliances beyond national boundaries and conventional strategies if it was to be won by nations constantly threatened with erasure by settler states. And that's where I will end it. I did want to post this here. I'll share this article with Marjorie, and maybe she can share it with the attendees of today's talk. But this just published a couple of days ago. If you're interested in reading it, it was published in Wichazo Shaw Review. So thank you so much.
And we are delighted that Leonard Peltier is finally been freed after all of these years, and he remains firm in his solidarity. Thank you, Nick, so much for putting the indigenous movement in the United States into an historical context of anti-imperialism, and for explaining how anti-communism in the United States had its roots in anti-indigenous efforts. Very, very fascinating, I thought, and the relationship between the Palestinian Liberation Movement and the Indigenous Peoples Movement in the United States. So thank you again for that. And Natalie, you're up.
Thank you, Marjorie, and thank you, Nick. And I do have a presentation that I believe Erin is going to share. Wonderful, thank you so much. Sumak punchay ayan chu nyohas timing Natalie Segovia nyoha hosko peru mantakani. Good morning, everyone, and good afternoon. My name is Natalie Segovia. As Marjorie already introduced, I have the honor of leading the Water Protector Legal Collective, a nonprofit law firm and advocacy organization that began as the on-the-ground legal team at Standing Rock and grew out of the No DAPL movement. In my work as an attorney, I've had the privilege of working across the Global South and Turtle Island, or so-called United States, on issues impacting Indigenous peoples and the earth, and have worked to address these issues at the grassroots level, which is my preferred area, but also in the courtrooms and within and beyond the UN system. And this moment, this talk that we're having today comes at a moment where we are seeing the international system unravel before our very eyes. What happens when Indigenous peoples finally enter the halls of the United Nations only to find that those walls are still built by the same colonial order. One of the questions I am often asked is, what's the big project you're working on at Water Protector Legal Collective? And often my response is that we are fighting invisibility. And so I want to share a little bit about the historical arc, next slide please, of Indigenous people's struggles for visibility in the international space. And although we didn't time it this way or even really coordinate presentations, a lot of the history that Nick shared immediately before me is part of the history that I'll talk about here today, but I'm talking about the broader contours. So the story of Indigenous peoples within the international system is one of persistence against erasure. Indigenous peoples were never meant to be subjects of international law, but rather were its objects. And I think that was clear from Hiroshi's presentation. For most of the 20th century, Indigenous peoples were invisible in the UN system, not because we were absent, but because the system was built on a foundation that could not see us, right? The sovereignty of the state. So in 1923, over 100 years ago, Cayuga Chief Descahe of the Haudenosaunee traveled to Geneva to petition the League of Nations. He sought recognition of the 6 nations of the Iroquois Confederacy, composed of the Mohawk, Oneida, Onondaga, Cayuga, Seneca, and Tuscarora nations, as a sovereign Indigenous nation governed by a hereditary council of chiefs. He was turned away and denied the right to speak because Indigenous nations were not recognized as sovereign nations. And this is a photo here of that journey. To this day, the Haudenosaunee Confederacy is considered one of the oldest self-governing peoples in the world. They are governed by the Great Law established more than 1,000 years ago, long before the arrival of colonizers in North America. Descahe's rejection became an early and symbolic moment of exclusion that foreshadowed nearly a century of Indigenous struggle for international recognition. Since then, and long before, our nations have fought not only against erasure and denationalization, but for the inherent sovereignty and self-determination of our peoples. Self-determination is not an abstract principle, it is a practice, it is a praxis, and an exercise of volition. In 1945, when the United Nations was founded, and today marks its 80th year anniversary, it enshrined the sovereign equality of states. This principle, seemingly universal, continued colonization at the level of global governance because Indigenous nations whose sovereignty predated states were still rendered invisible. The International Labor Organization, ILO, adopted Convention 107 in 1957 on Indigenous and tribal populations. And although this was progressive for its time, it still reflected an assimilationist mindset, setting Indigenous peoples as populations to be integrated, not sovereign nations. And so Nick's presentation covered a great part of the 1950s onwards into the 1970s. In the next slide, we see some photos from the 1970s. In that continued struggle for Indigenous peoples' struggle for visibility. So in the 1970s, Indigenous elders once again traveled to Geneva. So we're talking about from 1923, right, that initial trip by Descahe all the way to the 1970s. And in 1977, the first UN conference was held with Indigenous delegates, the International NGO Conference on Discrimination Against Indigenous Populations in the Americas in Geneva. And this was a watershed moment. It was the first time the UN engaged Indigenous leaders directly on our own terms, and it was demanded by Indigenous voices. The UN Subcommission on Human Rights soon called for a study on discrimination against Indigenous populations, led by Jose Martinez Cobo. His multi-volume study in the 1980s provided the first international definition of Indigenous peoples and affirmed our right to self-identification. In 1982, the UN Working Group on Indigenous Populations held its first meeting in Geneva, and for the first time, Indigenous delegates could directly address the UN. That date, August 9th, has become the International Day for the world's Indigenous peoples. I'm sorry. In 1989 as well, the ILO adopted Convention number 169, replacing the assimilationist ILO 107. So ILO 169 recognized that the Indigenous rights to land, culture, and consultation, but this was still within the framework of state sovereignty. And finally, the 1990s, we saw the International Decade of the World's Indigenous Peoples, during which time the visibility of Indigenous peoples increased, but it also revealed how state-centered the UN system remained. So we fast forward into the 2000s, and in 2007, the UN General Assembly adopted the United Nations Declaration on the Rights of Indigenous Peoples after more than 20 years of advocacy and negotiation. And importantly, 144 states voted in favor, and perhaps not surprisingly, for against Australia, Canada, New Zealand, and the United States, with 11 abstentions. Despite the abstentions and despite the no votes, it was a historic moment. This declaration affirmed that Indigenous peoples have collective rights, that we are rights holders and not relics of the past, and it codified principles of free, prior, and informed consent and the right to self-determination, among many others. But although the arc from 1923 to 2007 reflects a century of struggle from invisibility to so-called recognition, it is not a recognition or a full self-determination. In Article 46 of the UN Declaration on the Rights of Indigenous Peoples, it states, "Nothing in this declaration may be interpreted as implying for any state, people, group, or person any right to engage in any activity or to perform any act contrary to the Charter of the United Nations or consulted as authorizing or encouraging any action which would dismember or impair totally or in part the territorial integrity or political unity of sovereign and independent states." So Article 46 explicitly limits the right of self-determination to within the territorial integrity or political unity of states. This is a major compromise, and it's a painful one. The right to self-determination was affirmed only insofar as it did not challenge the supremacy of the state. So what Article 46 protects is the integrity of states, but not the integrity of the earth, and does not recognize and understand that we existed as Indigenous peoples and original nations before the existence of states. And that limitation reasserts the primacy of the state over the earth, and that is an ontology that is fundamentally at odds with Indigenous understandings of sovereignty as relationship and responsibility to land, waters, and future generations. In the words of Kenneth Deere, Haudenosaunee, he says, "Today at the United Nations, only states and NGOs can speak. So if you're not a member state, then you have to declare yourself as a non-governmental organization, an NGO, in order to register and to speak. We are governments, we are not NGOs. Indigenous peoples' governance is not recognized by the UN. We, the Haudenosaunee, refuse to register as an NGO. It has been 100 years now of that refusal." So this still echoes the colonial doctrines of discovery and dependency, where states are gatekeepers of Indigenous freedom. So even as we gained recognition in the international system, the international legal order continued to enclose our rights within its boundaries, cementing parallels to the US system of domestic dependent nations, part of the cornerstone of federal Indian law, and relegating indigenous nations to a quasi-sovereign status. The state remained the measure of legitimacy, while Indigenous nations and the earth remained unprotected under international law. We reject this. Today, we're seeing an international system in crisis. The international system itself is failing ecologically, politically, and morally. The erosion of trust in international institutions is clear: paralysis on genocide, climate collapse, and global inequalities. Indigenous peoples, despite formal recognition as rights holders continue to face seemingly insurmountable challenges. In Gaza, the United Nations has been unable to stop atrocities, even as its own commissions find that acts amounting to genocide have been committed. Repeated ceasefire resolutions are vetoed by powerful states, revealing that rules-based order is only as strong as those who benefit from it. An agreed-upon ceasefire has been violated again, and ultimately, in the face of overwhelming civilian death, the international system has been paralyzed, unable to uphold even its most basic humanitarian principles. In Ecuador, and this is a photo from the most recent ongoing national strike led by indigenous Quechua peoples and other Andean peoples, has lasted more than 20 days, has been met with violent repression, killings, and arrests, and I can't stress enough that this is ongoing. These violations of human rights continue to unfold despite Ecuador's commitments under international human rights law and the UN Declaration on the Rights of Indigenous Peoples. The silence and inaction of the international community in response expose a deep hypocrisy. The very system meant to safeguard Indigenous rights allows violence against Indigenous bodies with impunity. We are still invisible. Across the world, Indigenous peoples and land defenders continue to be criminalized and killed for protecting their territories. Global Witness reported that in 2024, at least 146 defenders were killed, 1/3 of them Indigenous, most of them protecting forests, rivers, lands, essential to planetary survival. These deaths are not isolated. They are symptoms of a system that privileges extraction over life. Even those who bring their voices to the UN, to Geneva, to New York, traveling hundreds of miles to speak for 2 minutes at the United Nations, often return home to threats, surveillance, and assassination. I've heard firsthand relatives from across the globe speak in the halls of the United Nations, and the stories are the same we've heard for now well over 500 years. We are in danger, but we are fighting for our existence, for the earth, for future generations. And still, sometimes it seems this is shouting into the void. There is a paradox here. There is increased participation, more Indigenous representation in spaces of international power, and still we are not safe. These are not simple failures of implementation. They are the consequences of an international order built on colonial foundations by design. It's a design structural flaw. A system that recognizes Indigenous rights on paper but continues to uphold the sovereignty of states over the sovereignty of the earth. So now, as the international order frays under ecological and geopolitical strain, the crisis of legitimacy in international institutions mirrors what Indigenous peoples have known for so long. The failure of state systems is a failure to uphold life. So where do we go from here? And this reflection and this question has been heavy on my mind for some time now. And in August, I was in Brasilia, where 7,000 Indigenous women from across Brazil gathered to march on the capital, demanding demarcation and protection of Indigenous territories that also safeguard some of the most biodiverse regions on Earth. Standing in that sea of movement and color and voices was an intergenerational reminder that self-determination is not a clause, is not words on paper, but a living practice, carried by people coming together for the land, water, and future generations. It reminded me that international solidarity must also live this way, and it has lived this way, not just as policy, but as acompañamiento, or accompaniment. It is not about abandoning the UN or the international system, but going beyond those spaces to something more enduring, an internationalism desde abajo or from below. Indigenous peoples have always practiced transnational solidarity and internationalism. From Standing Rock to the Amazon, from the Arctic to desert plateaus, through global networks of water protectors and land defenders. These relationships are not symbolic, they are protective, relational, and rooted in the shared defense of life itself. Accompaniment and solidarity at the grassroots level allow us to respond to what is most needed on the ground. It allows us to show up for one another when global institutions cannot and will not act. This is not the rejection of internationalism, but it is regeneration and reclamation of internationalism as community-based, community-centered, and grounded in reciprocity and human understanding. Lawyers, advocates, and movements have a role to play here in bridging the local and the global, in building networks of accompaniment, advocacy, and shared power that protect defenders and sustain life. The future of international law does not lie in written treaties or resolutions alone. It will be lived in relationships, in solidarity, in the daily acts of courageous people who refuse to give up on one another, and in the manifestation of self-determination as Indigenous nations continue to reject the myth that we are not nations in our own right. We reject that myth. We are older than the settler states that inhabit our ancestral lands. So in conclusion, recognition was never the endpoint. We didn't need to be recognized internationally to know that we existed before the creation even of states. Our presence in spaces of power that weren't built for us was always the beginning of a deeper reclamation. As the international system melts before our eyes, Indigenous peoples remind us that our greatest obligation is to the territorial integrity of the earth and the protection of life itself. The challenge and opportunity before us is to reclaim spaces and reimagine what lies beyond the colonial systems that still shape our world and root that imagining in responsibility to land, to each other, and to future generations. And this is one of the small girls that was at the protest in Brasilia, really leading at the very front, and the sign says Pelo futuro das meninas indígenas, or for the future of Indigenous girls. The law of the land must once again become the law of the heart, and that is the opportunity that we have before us. Thank you.
Thank you, Natalie, for detailing the historical arc for Indigenous peoples' struggle for visibility in the UN system and for explaining the UN Declaration on the Rights of Indigenous Peoples and why it is not based on the right to self-determination, but rather limited to the sovereignty of states, and also for explaining why solidarity is essential. Thank you so much. And thank you to all of our fabulous faculty members for your excellent presentations that I think dovetailed very nicely with one another. I want to start now by having a brief discussion between the faculty members, commenting on each other's presentations or adding things or asking questions, and then we will move into a period of questions and answers with you, the attendees. So if any of our faculty members would like to begin, go right ahead.
Maybe I start since I haven't spoken for a while. I have just comment to Natalie's excellent presentation, and she talked about Descahe, the indigenous leader, who led the delegate himself too, went to the headquarters of League of Nations to talk about the indigenous sovereignty and also importance for the indigenous peoples and nations to assert rights to self-determination. And it's quite important. And this is not the question, but he was also accompanied by many other indigenous people. And not only the Descahe was, of course, very prominent figure in the United States, in North America, but also other indigenous peoples from Africa, as well as the from New Zealand, for example. The leader of the New Zealand's indigenous nations also went to the headquarters of League of Nations to talk about the importance of rights to self-determination, given their settler colonial atrocities. And the reason I mention this is because all those indigenous sovereignty and insistence on their rights to self-determination was being triggered by the event that happened in 1919. That's when in the Paris conference, when the League of Nations was constructed, and they are trying to create the League of Nations Charter or Covenant, and in that conference, Japan had proposed something called the racial equality proposal and tried to eliminate racism in international law. And in Article 22 of the Covenant of International League of Nations, where it was being in the process of being created, it called for the elimination of discrimination on the basis of race and nationality. Nationality included the not the state citizenship, but those are the nations who have been captured within the state system. And so they're responding to the sub-state, the communities. Like in the case of Japan, for instance, there are many migrants to the United States and being discriminated as a group, as well as Chinese, as well as indigenous people. So this triggered the worldwide movement to move forward to eliminate racism, like a W.E.B. Du Bois, for instance. When this meeting was taking place in February of 1919, he organized a huge Pan-African conference to push this extra support from outside so that the League of Nations would pass this proposal. But unfortunately, despite the fact that the rights of people who had been captured within the sub-state system, including the racial groups and indigenous groups, under Woodrow Wilson, who acted as a chairperson of this proceeding, rejected this proposal because it didn't achieve the unanimity. But again, soon after that, there had been, again, a push for the same, or if not even stronger, protocols to assert the rights of indigenous nations and peoples. So I just want to mention this because the whole thing didn't happen out of vacuum. It became as a movement because of what's really happened in the attempts to create the League of Nations as the first global management system. In Japan, as the only non-white state, insisted the rights of not only non-white states, but also non-white people being colonized under European colonialism should have the same right, even though it was rejected. So it was more of a comment rather than a question. But I really appreciate your showing the wonderful picture of the chief, Cayuga chief. Thank you. I learned a great deal.
Thank you, Hiroshi. I just wanted to comment, one of the on both Hiroshi and Nick's excellent presentations. I think one of the things that often gets lost is the internationalism that I think we all touched on today in different ways and brought out, teased out different parts of the history. And what I'd like to, really emphasize here is that the histories are so broad. There is so much history, right? We have touched barely the tip of the iceberg in all of our presentations. And really it's because of time, but it's an invitation to everybody here to take the deeper dives and to do the studies. I know one of the things that you talked about, Hiroshi, was the NICT model, which I actually hadn't heard about, but I really appreciated the way that you talked about international with the hyphen. And it actually reminded me of a Lakota elder friend who years ago began using the term international. And so he does something similar, but really emphasizes the international aspect of nations, right? As original nations interacting with one another, and how this really predates the existence even of the current kind of nation state paradigm that we have and that we articulate usually in the international sphere. And then I really appreciated also your exposition about the impact of militarization on Indigenous peoples. I think that oftentimes the impact of militarization and militarism on Indigenous peoples, lands, waters, and well, all of the different components that that comes with, particularly in the Pacific, but all over the world where the U.S. military has reached, which is, as we know, many hundreds of, well, it's over 100 nations, um, has really impacted these places. And I believe this week at the UN begins the commemoration of demilitarization, or it's Demilitarization Week at the UN, kicked off by, today. But I don't think we can speak enough about the impact, both historical and contemporary, of what this is doing and the effects that it still has, and still the invisibility that this yields in the international system. Because as Hiroshi mentioned, those core problems, right, the structural harms are not addressed under international law. So it really leaves those blind spots of environmental devastation and cultural annihilation and gender depression and militarized oppression beyond the reach of justice. And I think, I saw a question somewhere in the chat about beyond the UN strategies, and I think that speaks to some of the internationalism and the history of internationalism that Nick was teasing out and talking about in his presentation, and that I was also alluding to, is that when the international system fails us, as it has done so often and continues to do, we have to find, other ways that are creative and that are different, and looking outside the structures that exist, to thinking about how can we create new structures, and how can we create new bonds and new relationships that can strengthen our ability to push for accountability and for justice when that is denied to our peoples systematically, and now our nations systematically. And I think Nick really did, talked about this history of Indigenous internationalism. And one of the things that I really appreciated in Nick's presentation was the idea that American Indian treaties are recognized by the U.S. Constitution as forming, seen as by the United States as sort of a concession to a supreme power, but how different that view is from the other side, right? As Indigenous peoples and original nations, seeing that as an understanding and a coming together. And I think that the view of treaties is something that we haven't discussed, at great length today, but how important those treaties are in the international space and also in the U.S. constitutional paradigms, right? We have the Supremacy Clause of the U.S. that recognizes treaties as the supreme law of the land. And this, although it's enshrined in our Constitution and we're taught this in law school, we're never taught that the Supremacy Clause of the United States also recognize, and when they're saying recognition of treaties, includes American Indian treaties, right? And I think that's an important thing to kind of bear in mind. And I'll put in a plug for Lakota Nation versus the United States. Nick was one of the historians that speaks in that documentary, but there's a moment where he talks about, and he didn't say it today, but talks about American history often sees itself as larger than, but in reality, the history of American Indian or Indigenous peoples of Turtle Island are the tree, and American history is a branch, right, and not the other way around. So I really appreciated, all of those discussions that you were able to tease out, Nick, and Thank you both for these really engaging discussions.
Thank you so much for that, and I hope people do check out that documentary. Do any of the faculty want to add anything before we go to the questions from the attendees?
Yeah, I'll just say that I really appreciated both presentations, and I was thinking as Hiroshi was talking about militarization in the Pacific, and then also Natalie was talking about sort of modern era of the decline of international law, deterioration of international law, and how much maybe we also need to have analysis of geopolitics and political economy in these conversations, because sometimes militarism isn't just for the sake of militarism, but it's for the sake of securing markets. Whether it's in the case of securing access to oil and gas in North America and the carbon infrastructure that ties into these pipelines and these zones of extraction, but also the way that the United States, for example, relates to other sort of oil producing or oil rich nations, when we can look at the recent intensification of military threats against, like Venezuela, or the militarization of the Caribbean, as related to, this notion of a quote unquote narco terrorist. But if you really peel back the layers and look at what Marco Rubio is saying, he's saying that they're trying to protect, this U.S. oil interests in the region. And in this conversation is lost the indigenous people who live, in the border region of Guyana and Venezuela, and how these sanctions and this increased militarization of this area really affects and impacts their livelihoods. But it also is also directly related to the pipeline struggles that we face in North America, because not just the Trump administration, but previous administrations, whether it was Biden or Obama before him, push for the increase in domestic production of oil, largely at the expense of indigenous sovereignty and indigenous nations. And so I always, even the militarization of the Pacific, it's about a containment strategy in the new Cold War with China. So I just think of how the frameworks that Hiroshi and Natalie were putting forward might be useful for also understanding sort of these, what we might call, like, great power politics, but understanding that indigenous peoples aren't sort of minor players in this, but they're very central, and oftentimes the most made the most vulnerable by these sort of politics. And I really appreciated listening to both of you talk. And as somebody who's not a legal person, I'm just reminded of the care and attention that you guys have around language and the specificities that you provide in terms of articulating rights, and how useful that can be for people who are organizing on the ground, but also for understanding social movements and how they interpret and use these frameworks. So much love and solidarity to both of you. I really appreciated your comments and also your presentations.
Thank you so much, Nick. If there are no other comments from the faculty, then we'll move into the questions. Natalie, you highlighted one of the questions that caught my eye, and that is, can you give examples of beyond the UN strategies and practices to foster change at the global level? And I would add to that both legal and political strategies based upon what Nick just said. Would either any of you like to comment on that? Some examples of beyond the UN strategies and practices?
I can touch on that briefly, but I know Hiroshi and Nick probably have a lot of ideas on this too. I think the example I wanted to highlight was the international solidarity on the ground, in spaces with indigenous-led and community-led efforts. I think oftentimes it's easy to kind of see internationalism as an international solidarity and accompaniment having to occur at a very high level, and I want to challenge that. I think it's really important to, and that was, I think, one of my broader points was thinking about internationalism from below, right? Thinking about it at a grassroots level, thinking about how do we connect on a very human level and building those relationships. Beyond the UN strategies is really, I think, a call to looking outside of just the systems that exist and thinking about systems that we can build, and beyond systems that we can build, relationships that we can build. So I think it's a very much, for at least for me, a call for relationship building and true solidarity, and that indigenous transnationalism has been, and internationalism has been, something that's been happening for centuries. I think the other thing I would just say on that is, one of my mentors was Tupac Enrique Costa, and he was a big proponent of challenging the idea that we had to um, give any sort of deference to the territorial integrity of the state, and that our ultimate obligation was always to the territorial integrity of the earth. But as part of that, really thinking about the he used to ask, "What is the juris genesis of the law?" And he would ask it every time I'd introduce law students to him. And I think it's one of those foundational questions that you don't always ask yourself as a lawyer or as a normal everyday person. Where does the law come from? And how does the law exist? And what are its where does that power derive from? And I think even beginning to ask those questions is part of beginning to reimagine some of those strategies of beyond the UN, right? And thinking about the advocacy and education and awareness that we can do individually on our own, and sharing those stories that are still so invisible in everyday life.
Thanks for that. Hiroshi, yeah, go ahead.
Maybe I wish to thank you, Natalie, for the wonderful comments and elaborations. And also, I want to talk about a little bit about UN. And as I mentioned about League of Nations, UN is not only the prominent international global management system based on the statist principles, but also we need to look at the League of Nations, why it failed too. League of Nations became the first statist management system, came out of the First World War. Again, just like UN, League of Nations was created by the victors of those conflicts. And so they have certain agendas. And like I said, Japan recognized that and tried to institute the law into the covenant of League of Nations to eliminate racism from international law. It failed. But again, like a UN created in 1945, created by the victors. And so it's one thing that we need to be aware of. And consequently, the judicial body, like ICC or ICJ, and ICC was created into practice 2002, but it was on the table for many decades, thanks to the many oppositions, largely from the United States, from its articulation into the practice. And even though if you look at ICC, as I said, or any other tribunals created under the international coalitions, the responsibility is sought to and to the individuals, and not the collective entities. Even when you look at the Nuremberg trial, and prosecutors realize the horrendous instances of IG Farben, the corporation, manufactured toxic gas, killing many people, Jews, Slavs, homosexuals, many others. But instead of punishment against this collective entity, which being managed by many investors, international investors, but punishment rendered on those executives. And IG Farben, as you know, had been morphed into other pharmaceutical companies, like a Bayer's or a BCFF. And again, those are the companies which became really giant. And recently, Bayer incorporated Monsanto, which produced Agent Orange, made tremendous amount of profit out of Vietnam War. And so it's quite important. I think NICT looks into this responsibility of collective entities, not just corporations, but the agencies and institutions. So I think that's one thing we need to pay more attention to when we talk about the judicial accountability.
Can I just
Thank
add,
go-
Marjorie,
Sure.
briefly, one of the things that Hiroshi, and maybe you can talk about this, Hiroshi, NICT and the NICT model that you raised, you talked about Indigenous juries. And actually at the conference in Brasilia in August, they had an Indigenous jury. And it was an Indigenous jury made entirely of women. And it was also a moment where Indigenous women, girls, and women elders came together as part of this moment where there was also, aside from the march, a space where there was, the denunciation of crimes that had been committed, of femicide, of rape, of ecocide, and the Indigenous juries as a very strong alternative. The same with people's tribunals, which there's the Gaza People's Tribunal happening now, currently as we are speaking today. There have been many other people's tribunals also as sort of alternatives to the international system. So I'd love if you could comment a little bit on that as also an alternative strategy.
Yes, thank you very much. That's great. Those are indigenous juries, which have tremendous implications in terms of the kinds of sense of justice achieved in the community in which crimes being taken place. And it's a great tendency. And the reason I mentioned about the jurado indígena in Spanish, English it's indigenous jury, which is the state adapted system. It became part of the judicial body, so to speak, in Argentina starting from 2011. And Argentina suffered the tremendous military dictatorship from 1970 to 1980, and tens of thousands of people disappeared and gone. So people who suffered such military dictatorship, along with young lawyers and the Indigenous Nations and also young activists, created this citizens body, INECP, INECP. And that also pushed the legislation to pass the jury system, which had a precedent. That was a strength of that movement. Strength is called in Latin, the juri de mediate linguae. Even it has a precedent in England. It was adopted in 12th century in England that the King Richard, given the tremendous communal discrimination against Jews. And so King Richard had adopted this juri de mediate linguae in Latin, means it's a jury of half tongue. Tongue doesn't mean the physical tongue in our mouth, but tongue represents culture, the language. So Jewish people had the right to send the 6 people out of a 12-member jury to compose the ethically, culturally diverse jury. And that system, believe it or not, being adopted in North America. And it practiced until the 20th century, until the Supreme Court of the United States said no longer it's the attainable. So the Argentina had used that legal tradition from the United States, from England, as a model to create the judicial body, at least a local level, in which using a random selection, the people names came from all the people live in the community. The half of the members would come from the indigenous community, the other half from non-indigenous community. And the first trial took place 2015 in the indigenous land for the multinational corporations tried to explore, again, here you go, for minerals in the indigenous lands. And the indigenous people resisted. And they are being accused of violence and even the second-degree murder. And after a week of jury proceeding, they are being acquitted. So, again, NICT had adopted this jurado indígena as a method to ensure the voices of indigenous people need to be reflected, not only in the discussions, but on the verdict itself. So it's great tendency in Brazil.
I'd like to add something. Hiroshi, you mentioned Agent Orange, that the US military used as a chemical weapon of war in the American war in Vietnam. And even though the Paris peace talks guaranteed reparations to the Vietnamese people, that has not been forthcoming. And there was an international tribunal of conscience in support of the victims of Agent Orange in 2009 in Paris, a 3-day tribunal. I was involved with that as a judge, but there were many Vietnamese witnesses, victims, journalists, also US service members who had been poisoned by Agent Orange as well. And one of the things that the tribunal concluded was that in addition to conclusions that the US committed a war of aggression, illegal war of aggression in Vietnam, was that the US committed ecocide. And you mentioned ecocide as well, but ecocide has not yet been recognized in the traditional international law system, for example, in the Rome Statute for the International Criminal Court yet, as a crime. And that's something that also impacts the fight for indigenous rights and to protect the land in this country and in other countries as well. So I wanted to add that. We have some more questions. We have one that Hiroshi might want to address. How do institutions like the NICT ensure that bad actors don't cynically weaponize the indigenous status to advance settler colonial goals? Particularly the example of the Zionist claim that Jews are indigenous to Palestine in order to justify settlement expansion and deny Palestinian human rights?
That's a great question. I think as Natalie indicated the importance of history, I think in responding to that, I think we need to look at how Palestine came out in the first place and how Israel as a military state came about. So the Palestine was created under a British mandate system. Again, that goes back to the First World War. And the League of Nations established with support of Britain and France and the victors, created something called the mandate system and tried to partition the lands of those who were losers of the First World War. In this case, particularly the Ottoman Empire. And Ottoman Empire was deconstructed into partitions by the mandate system, largely led by Britain, which created Palestine as well as Transjordan and Iraq. And the French also had a hand in that mandate system, created and controlled the Syria, and later Lebanon had emerged. So Palestine was the colonial compartment created by Britain. It's very similar how Britain had controlled those regions. Just look at the starting from Barbados, the first Caribbean island that Britain had controlled, and as well as to North America, bringing settlers. And what settlers do? Well, they dispossessed indigenous land. In the process, they liquidated the indigenous populations. So this is English settler colonialism. And after England took over largely the Ireland and Scotland and Wales. They became Britain. So under the British colonial system, the various colonial compartments being created. Australia from 1788, New Zealand, and even after the First Boer War in South Africa, Africa came under the control of Britain. And again, settler colonialism being instituted. So if you look at today, Palestine, and the white was being instituted in North America to include almost everyone with European descents, despite the fact, if you look at Europe, like we discussed about the First World War, the Europe had been a blood battle place among various groups, English versus Irish, English versus Scots, English versus Welsh, English or British versus French, French versus Germany, German versus Russia, Russian versus Ukrainians, Northern Italian versus Southern Italians. But under British system, using this white, everybody from Europe, immigrants, despite all those conflictual and bloody history, they are being given the nomenclature of white. And they created militia to exterminate indigenous populations. And you see the same pattern in Palestine. The settlers united together under the banner of Jewish identity, this ethno-religious identity, very similar to whiteness being constructed in North America and elsewhere, and engaged in the settler colonial projects. So when we talk about settler colonial projects, it was actually the term used to critique the Israeli policies of wiping out indigenous populations, starting from the 1990s to year 2000 until now. But not many people paid attention to the settler colonial policies imposed in North America. So under the English colonial system, Palestine is a creation and Israeli is simply a spawn out of it. So that's how I see it. It's simply the continuation of settler colonial policies imposed in the Middle East. And the indigenous people need to get together, as Nick has talked about. And I'm from UC Santa Cruz. The school for the Huey P. Newton earned not only bachelor's and PhD. And you see pictures of Huey P. Newton, co-founder of Black Panther Party, meeting Yasser Arafat. And so based on Marxist-Leninist traditions, Black Panthers reached out people who need to liberate themselves from European colonialism. So Black Panther and the Black activists, nationalists, had been working also together with the Palestinians for the liberation. And the UC Santa Cruz and the graduate students like Huey P. Newton had been at the midst of that struggle and liberation movement.
Thank you, Hiroshi. We have another question. How does the NICT deal with the paradox of operating within an international legal grammar that it simultaneously denounces as colonial, particularly regarding the validity of its decisions, transnational jurisdiction, recognition, and the non-symbolic enforceability of its sentences?
That's an excellent question. NICT has a very short history. And currently, the Indigenous Confederation, called the Confederation of Indigenous Nations of Middle East and North Africa, CIM-MESA, had adopted the NICT Charter. And they are trying to create the NICT court, especially on behalf of Yazidi people. Yazidi Nation, or called Yazidi Nation, had been suffering from the discrimination, most prominently 2014, they called the Yazidi genocide by the hands of the extremists. And they have recently adopted NICT. And again, NICT as the adjudicative body is willing to work with the international organizations. And as I mentioned, one of the mechanisms that they have adopted was the Prosecution Review Commission. What is Prosecution Review Commission? Oh, it's the grand jury system adopted in Japan, thanks to the Allied forces after the end of Second World War, especially from the United States. They pushed Japan to adopt the grand jury system, except the grand jury system in the United States look at the allegation of crimes and they make decisions. See, those grand jury bodies composed of the residents, they're not lawyers, they are not judges, but they are the people who are randomly collected from the community, and they will look at decisions the prosecutors decided not to proceed. In other way of saying, because many of the state prosecutors are extremely reluctant to move forward with the prosecution of powerful people and organizations. So those no indictment decisions by this body tend to be benefiting the economic elites, prominent politicians, political organizations, and so on. So by adopting this body, this NICT will look at the decisions made by the state system within which indigenous nation has been located, and look at using that no indictment as a platform to evaluate and re-bring the case before the court. So in other way of saying, the NICT has a mechanisms to collaborate and cooperate with the state prosecutorial bodies in cases those bodies became reluctant, even though they probably know certain politicians need to be examined or maybe possibly criminalized, or even institutions need to be looked into, especially corporate bodies. But since they are too powerful, so state body cannot move forward, but they can actually collaborate with the NICT to re-evaluate, re-examine those cases, and using the NICT body to prosecute, move forward with the prosecution. Again, this is very new, and we don't have any examples that we can talk about. But hopefully, in this CIMMESA, the collection and confederation of 60 plus indigenous nations in the Middle East and North Africa. I hope many indigenous nations will look at the charter, which is available online, and look into the possible utilization of this body to advance the interests and wishes of indigenous peoples and indigenous nations.
What implications, if any, does UNDPOP have for Indigenous rights? That's the UN Declaration on the Rights of Peasants and Other People Working in Rural Areas.
Certainly they can work, they can adapt NICT, definitely. But again, as Marjorie kindly mentioned about the ecocide is not being included under ICC jurisdiction, even though it's now in current discussion, as we know of, to include the ecocide into the not only indictable offense, but also prosecutable and should be prosecuted. But as I mentioned in my presentation, and I want to repeat, they tend to look into the responsibility that reduced to the individual level. Okay, but ecocide is not something the CEO of some corporations actually caused, but it's a corporate entity of corporation itself, the entity that seeks to make profit, basically no matter what. And if CEO didn't agree with that objective of what a private corporation should be, that CEO will be replaced. So it's not the individual shuffling of the corporations would lead to the solution and dissolution of the problem of ecocide. But this adjudicative body, the philosophy itself, needs to be transformed. And that's why NICT can become the entry point to shift this prosecutorial means and methods, moving away from individuals, but into a collective body. And as I mentioned, like a state, corporation is ephemeral. It's a legal fiction. And you cannot hug, you cannot kiss, you cannot embrace with your body. It exists in our mind as a legal construct. And that also means that it takes our efforts, cognitive efforts, to see it as it is, and then challenge its constructiveness. And maybe we can incorporate that cognitive reality into this the adjudicative process of the NICT proceeding, hopefully in the future. I hope it makes sense.
Thank you.
Marjorie, can I just add something about to the prior question on the non-symbolic enforceability of sentences by the NICT? I think this is a common question that comes up not just in the context of NICT, but also people's tribunals more broadly. Like, what is the result of a people's tribunal, and does it actually have teeth? And then that same question is, brought up often in terms of the UN system itself, right? You have many decisions by the Inter-American Commission, and you have other UN bodies and mechanisms that have rendered opinions. And there's this question of, to what extent are they even enforceable? And you have many judgments. I believe there was actually a gathering earlier this year on the IACHR and opinions rendered in the past 10 years where there are judgments against nation states that have failed to uphold and failed to, actually enforce those judgments. And I think we've seen that even in the case of Gaza, right? So I think that that's a broader question of to what degree is the enforceability of the sentences something that we have to prioritize. And I think there's often a push to emphasize that symbolism is sort of dead, right? That it's not important and that it doesn't have a role. And I think we really have to reject that notion. I think the symbolic power can't really be undermined. I think it's one of the things that really begins, to create a seed for conversation and also visibility, which is something that I think we're regularly struggling against, right, as Indigenous peoples and as human rights defenders that are looking to challenge manifest injustice across the world. So I just wanted to address that that piece of the question, and thank you so much, Hiroshi, for your wrestling with all of those questions.
Yeah, not only, I think it's very important, very extremely important point. And again, NICT is just one suggested adjudicative body. And again, it has no history. But the way I could respond to your question is what the Frederick Douglass and many other activists had been saying. The power to enforce whatever the decisions being made by any organizations or any entities, the enforceability must come from the collaboration from the bottom. And the people at the top would not all of a sudden realize, well, they have too much power. They must relegate their powers, or they must relegate their authorities. So what about decisions being made? And those need to be delegated equally along the lines of people and so on and so forth. So enforceability, the power to put pressure on those entities must come from the bottom, always. And so my response would be, we need to work together collaboratively and continue working to the point where we have enough power to enforce the entities to act as it's supposed to act, to meet and deliver the decisions that would meet the needs and the wishes of the people. And again, NICT has certain mechanisms that will delegate the authorities through the collaboration with the state system. Again, as long as the state systems are not willing, there's almost no chance of imposing whatever the decision is being made. But again, it can work as a symbolic means. So the reason I instituted Jurado Indígena or PRC, those are people-based judicial bodies, and which had been already sanctioned as a legitimate bodies by the state. And it has a long history in the case of Jurado Indígena. So by instituting those mechanisms, at least under the NICT Charter, it had some international power of the persuasion. But again, many other means of persuading in terms of the stopping the ecocide and culture side and the feminicide, gender side, and it still requires much more collaboration and solidarity from the bottom. I'm not sure whether I answered directly to the question he answered, but that's the best way I could.
Thank you, Hiroshi. And I'd like to follow up briefly. I agree with both of you that we should not underestimate the symbolic value of international tribunals making certain rulings. For example, 2 days ago, the International Court of Justice, the World Court, the highest body, legal body in the world, as part of the UN system, ruled that Israel cannot use starvation as a weapon of war. And of course, Israel and the United States immediately rejected that finding and made a lot of accusations. But I think it goes beyond symbolic. I think there's also diplomatic and political ramifications for example, the World Court decisions. Last year, the World Court, the ICJ, ruled that Israel's occupation of the Palestinian territories was illegal and instructed all states who are members of the UN, not to recognize the legality of Israel's claimed sovereignty over the occupied territories. And since then, as a result of that decision and, of course, popular struggle, many states are recognizing Palestine as a state. And so I think that it's important not to underestimate how important these rulings are, even though we often hear they're non-binding, they don't have any legal effect. There's another concept in international law that's called the mobilization of shame. The mobilization of shame, which means that when the International Court of Justice or the International Criminal Court, which has arrest warrants pending against Netanyahu and former Defense Minister Gallant, Foreign Minister Gallant, for war crimes and crimes against humanity for their campaign of starvation and targeting civilians. So the mobilization of shame means that these decisions shame Israel in the eyes of the world. And of course, those ubiquitous photos for the last 2 years of Israel's horrific genocide against the people of Gaza have led millions of people to take to the streets in solidarity with the Palestinians. And I think that has largely been a factor in this recent truce. We'll see how long that lasts, but nevertheless, I think that so-called symbolic impact is also very important. We have another question. How many law schools teach about Indigenous rights and put international law into a more comprehensive framework? And what is the role of casinos for Native sovereignty and culture? And Kavanaugh, who is a member of the US Supreme Court, I never referred to them as justices, but a member of the Supreme Court, his jurisprudence and its effect on US law, if either of you would like to tackle that.
I can start with the first part of that question in particular about how many law schools teach any of this. As a person that works with law students from across the country, I am constantly reminded of the fact that this is not an active part of the law school curriculum or law school education, unfortunately. It's also not taught in US constitutional jurisprudence. So even though I think one of the reigning sort of myths in US constitutional jurisprudence is the tale of two sovereigns, the federal government and the state, or the states. And they routinely ignore a third sovereign, which are tribes, right? Original nations, and especially federally recognized tribes. What's also routinely ignored in US constitutional jurisprudence and the teaching of constitutional law in law schools is that federal Indian law, the body of law that addresses the government to government relationship between federal Indian tribes and the US government, not just treaty obligations, but an entire body of law, is entirely made up of constitutional law. And that is also regularly not addressed and not covered in constitutional law courses. And so I do believe that this is a great disservice that is perpetuated by the academy, by the legal academy, in that lawyers that are formed in the United States graduate from law school with a false sense of not just history and political history and legal history, but understanding how tribes intersect and how sovereignty and the sovereignty of tribal nations intersect into the broader discussion of constitutional rights within a US legal framework. And then in terms of international law, even though international law is taught at many law schools these days, I think that there is a similar blind spot for Indigenous rights and Indigenous people's struggles for visibility within the international system, even within those international law courses. So thank you to Marjorie and for the People's Academy of International Law for highlighting this particular blind spot in this discussion today and other discussions. But there is a renewed push, and there is a need for not just additional scholarship, but additional space within the legal profession for people to understand the importance of this kind of education within the American or US based legal profession. And at present, it's an immense disservice.
How does the case of Navajo Nations versus Arizona 2023 case impact DAPL litigation, if at all?
So I answered this in text, but I can elaborate a little bit and just say to those that might not have looked in the Q&A. So in the Navajo Nation case, which is a recent Supreme Court decision, the Supreme Court ruled that the United States government does not have an affirmative duty based on a trust obligation to take steps to secure water for the Navajo Nation, despite a treaty and reserved water rights. So this decision is primarily based in terms of the Colorado River, but I think it could have broader water rights issues, including the limited scope of the federal government trust responsibility regarding Native American water rights more broadly, and could shape also how courts view tribal claims against federal agencies. The struggle, and this is again, we were talking about the kind of blind spots within the legal education, often in environmental law, the Indigenous struggles to protect Indigenous lands from extraction, from mineral leasing, from exploitation are not directly covered. So in terms of DAPL litigation or Dakota Access Pipeline litigation, although not directly related to Navajo Nation, the Navajo Nation case, in terms of water rights, it does, that litigation does bring up issues of how the federal government and federal agencies like the U.S. Army Corps of Engineers continue to allow permitting of pipelines and extractive projects across unceded, right, unceded treaty lands, which are unrelinquished lands, ancestral lands of tribal nations that are set aside and guaranteed to tribal nations through treaties that have been broken time and time again. So the Dakota Access Pipeline is a key example of that, where the 1851 and 1868 treaties of Fort Laramie set aside the entirety of the Black Hills as land for the Oceti-Sakowing or Seven Council Fires. And in those spaces, those are unceded treaty lands, right? Those are the lands that are supposed to be guaranteed to the Oceti-Sakowing. So long as the grass grows green is actually the phrase that's used in that treaty. And then in 1980, the U.S. Supreme Court found in Sioux Nation versus United States that that there had been the illegal taking of the Black Hills, that the Black Hills, when it was open to gold exploitation through a gold rush that actually began with Custer, accompanied by members of the U.S. Army Corps of Engineers into the Black Hills to find gold on an expedition, which eventually resulted in the forced relocation of Lakota, Dakota, and Nakota peoples. This is the land that the Dakota Access Pipeline was built across, and not just built across, but under the waters of Lake Oahe, currently endangering the drinking water of the Standing Rock Sioux tribe. So although the Navajo Nation case is not directly related to the water claims, it does, I think, broadly or more broadly relate to how how federal obligations extend to tribes in terms of tribal consultation. Tribal consultation is sort of a landmark of not just federal Indian law and required under laws like the National Historic Preservation Act, under the National Environmental Policy Act, and are parts of the environmental body of environmental law, also not often covered. And I'm talking about Section 106 tribal consultation and Section 110 consultation under NHPA. These kinds of consultation are also looked at internationally as the right to free, prior, and informed consent. So looking beyond the idea of consultation in the US paradigm as a checking the box consultation. I've consulted with Hiroshi over here, right? But consultation doesn't mean consent. So the broader international call for a standard of free, prior, and informed consent that truly provides meaningful consultation on issues that are key to the inherent sovereignty of Indigenous peoples and original nations. And that is what I think the Navajo Nation case could potentially affect, among other things.
Yes, I believe it was Nick who mentioned Venezuela, and we have a question which is slightly outside the purview of this course, but I think bears comment. And that is, the current U.S. military aggression in the Caribbean seems to be a prime example of the violations under discussion. Can the panelists suggest emergency responses we can take? And I think that they're talking about Trump's killing of people, claiming that they are from Venezuela and other places, that they're bringing drugs over, and he has declared war on drug cartels. I can just start out by saying this is a blatant violation of the UN Charter, which does not allow an attack, an armed attack, except in response to an armed attack by another UN state. And also, and it looks like he's moving steadily but surely in the direction of forcible regime change in Venezuela, which of course is related to the fact that Venezuela is probably the richest country in the world in oil. Forcible regime change violates both the UN Charter, the right to self-determination, and the International Covenant on Civil and Political Rights, both highly illegal. We're seeing very little pushback from the US Congress, which seems to be AWOL on this and a number of other issues. So if either of you would like to comment on that, that would be great.
Maybe in the case of Venezuela, as Marjorie said, it's been targeted by the current administration. And I think 47th president directly said very horrendous expression of the Venezuela and its leader. And again, maybe it's outside the purview of legal discussions, but nonetheless, indigenous people in Venezuela had suffered under the governmental oppression, and it's only more of a recent under Hugo Chavez, when he became president, 1999. He began to look at the not only indigenous people but also Afro-Venezuelan people, which had been at the end of the not only the marginalization but in some cases starvation. So he instituted a program to help those people. And at the same time, they also suffer from all kinds of disease. So he worked with the Cuban government and sent the many Cuban doctors to be dispatched strategically in indigenous villages and towns, where for the first time, many of those indigenous people and Afro-Venezuelan people had the chance to even see doctors. And again, those are some of the socialist principles being adopted under Hugo Chavez administration. As you know, what happened in 2002, the U.S. Intelligence operations tried to collaborate with the insiders of the Venezuelan military, kidnapped and nonetheless, again, because of the people's uprisings and that rebels retreated and safely brought Hugo Chavez back into his position. But the prosecution and the strategies and the trade sanctions, economic sanctions continue, which still continue today. But again, it's quite important, as Black Panther had worked with many of the socialist groups, including indigenous people. As I said, the Huey P. Newton worked not only with the Yasser Arafat, but also the Black Panther Party members worked with the Rhodesia and tried to become independent, which became Zimbabwe and indigenous people, even Angola, and again, Cuba was instrumental for the independence. But anyway, so Venezuela had been on the side of, at least from governmental point of view, to provide and support the indigenous people. And I think that, and the Afro-Venezuelan people, I think that strategy is quite important, I think, in today. And again, it's outside the purview, and I apologize.
Well, one thing you mentioned were sanctions, US sanctions against Venezuela. And there was a People's Tribunal, I think it was last year, I was involved in that as well, on sanctions and unilateral coercive measures, particularly in Venezuela, Cuba, the US blockade against Cuba, Gaza, etc. The blockade against Gaza. And the reason that they're unilateral is because the UN Charter gives only the Security Council the power to levy forceful and non-forceful measures. In other words, the use of military force or the use of things like sanctions. And when countries levy these sanctions. It's called unilateral coercive measures without the permission or the direction of the Security Council. And during this People's Tribunal, and Nathalie mentioned People's Tribunals, we had testimony from people in these various countries under sanction, and we had testimony of some people who were in Gaza as they were testifying on Zoom, and they would have to stop their testimony and say, wait a minute, there's a bomb going off in our neighborhood. They were actually they were being bombed by Israel as that tribunal was taking place, as they were providing testimony. And I think that's really emblematic of what Israel is doing with the support of the U.S. They couldn't do what they do without the support of U.S. Military, money, diplomatic support, financial support, etc. And so it is connected.
Marjorie, can I just add here? I
Yeah.
think that this last question is almost a broader question in some ways of, what can we do, right? There's the question of like suggesting emergency responses and what responses can we take. And I think one of the things that I see increasingly in the face of so much crisis and human rights violations that are happening seemingly daily internationally, but also here at home in the United States, right? We don't need to look too far. There's so many kind of urgent moments that are happening, and I could rattle off a list, right? There's proposed copper mining at Oak Flat that threatens a sacred site in Arizona's copper mines, but it's sacred to Western Apache nations. That could happen at any time, and there's been 20 plus years of opposition to that. The Arctic coastal plain was just open to oil drilling literally yesterday. And this was an Arctic refuge, right? A wildlife refuge that has been protected. The Line 5 pipeline and tunnel are continuously opposed, have been opposed by over 30 tribes in the past several years, and is still operational. DAPL, Dakota Access Pipeline, is still operational without a permit. So I think there's a question that arises, and I think this question kind of at the heart of this last question is, what can we do? When we're seeing all of these things and feeling powerless and not seeing the international systems effectively dealing with these blind spots, that Hiroshi has talked about are structural. And I think, part of this conversation is an invitation for creativity and an invitation for solidarity and an invitation for reimagining. But I think there are some concrete things that we can point to as well, right? We've pointed to people's tribunals, and these are, one strategy, but I think on a daily basis, we have the ability to mobilize ourselves, our social media, regional, global media. There's ways that we can continue to support local civil society and put pressure on not just our local governments and elected officials, but also broader officials, and look to mobilize diplomatic pressure. I think sometimes there's a sort of a lack of response internationally by international human rights bodies that people find incredibly frustrating. I know I've been receiving over the course of the last couple of weeks, questions from relatives in the Andean region of what can we do? Why aren't these voices being heard? And again, that kind of goes back to what I was talking about earlier. Sometimes as Indigenous peoples, it seems like we're screaming into the void, right? There's this human rights world of human rights frameworks that exist, and they're not listening, right? But I do think that people are listening, and I think that beyond the algorithms that seek to silence our voices, we have the ability to share with, the old school way of sharing with our neighbors and sharing with our families and sharing with the people that are in our communities, and building and amplifying those voices and applying nonviolent pressure to curb not just U.S. military aggression, but the human rights violations that we're seeing on a daily basis, I think, and that's a human rights mantle that I invite everyone here to take up with us.
Well, thank you so much, Nathalie. That is a great way to end this program. Thank you to our esteemed faculty, our administrator, our interpreters, as well as the People's Academy Task Force. The next program of the People's Academy of International Law will be Course 10, International Law Protects Struggles for Liberation and Emancipation. It will take place on Wednesday, November 19th, and you will receive an email notice of the program. So thank you again all for participating, for all of our attendees, for your great questions, and we hope to see you next month at our next program. Thank you so much.
Thank you very much.
Thank you.
Bye.